There's no set rule of what to do with reduction of rent, and everything has to be done on a case-by-case basis. And if you're fixing everything and keeping everything perfect, that's not even gonna come up. How many times people go, I'm evicted, but I still wanna make good? Great, that's 1 in a million people. Most people go after them, you can try to collect, maybe you'll get a judgment, maybe you won't, and then you can chase them for the money. Number one is make sure your property is in perfect condition and fix everything right away, because then you're taking their thunder. If they're thinking they're gonna be able to withhold rent and buy time and not pay you because the place is in bad condition, well then just shoot that down and make sure everything's perfect. There's no self-help in Florida. If you could just go in and change the locks, then we wouldn't even be having this conversation right now.
Is it a myth that renting to a person that has minor children or an elderly person make the process of eviction longer? Welcome to another episode of The Raw Truth. It's a platform and a channel dedicated to real estate agents, loan officers, and consumers direct, to be able to provide valuable insights on everything that has to do with real estate and many other things. And today I have the pleasure to introduce Robert Warman. He is an attorney, graduated from George Washington University and University of Miami. For me, the experience with him on a case that was just handled on evictions was handled phenomenal. So I wanted to invite him to the office and basically go through the steps of an eviction process, the do's, the don'ts, the good, the bad, and the ugly. So welcome to The Raw Truth, Robert.
No, thank you. Really appreciate you having me, Iris.
So Robert, we met through a personal case of mine, and the whole process was handled, in my opinion, amazingly. I am a person that has little to no time on most days, and I'm sure you got a whiff of that. And we just got caught into a jam with tenants because we tried to accommodate them a little bit too much, right? So I want you to walk us through the initial problem of where a landlord can pinpoint a problem where they're going to have to evict a tenant.
It's a great question. It's a great way of phrasing it. And by the way, thank you for having me. I really, really appreciate it. And I'm glad you think I did such a good job on your case, because quite honestly, that was one of those cases I just told you a moment ago. That's probably the hardest case I've had to resolve all year. And it's not necessarily an aberration, but the way you phrase the question is exactly how I try to handle things with my clients, which is if you prepare and you do things correctly, and all your paperwork and all your preparation is done properly, then you could avoid the problems that you end up having. And the first thing I think everybody's got to do is make sure that their property is in good condition, because that's the number one complaint and the number one place things can go bad. Any problems should be dealt with immediately, even if you think it's a BS problem. Okay, there's a problem, send somebody immediately, check it out immediately. And doing an accommodation is not a big deal. I don't necessarily know if you want to get in the weeds with your case in particular, but the issue with your case was purely maintenance. And if your property is in great shape and you know it's in great shape, then that's number one.
I think that my question into my particular case would be, when does the landlord have the right to reduce the rent?
Well, the lease speaks for itself. And that was part of your case that actually helped me. You never really put anything specifically in writing. A contract has to be in writing and signed by all parties, right? I mean, you could have a month-to-month agreement, but you had a written lease. The written lease said what the rent was. There is no, I have a right to reduce the rent. I mean, you can make an agreement and an accommodation anytime. Legally speaking, the issue is, what is the value, or how does if there is a problem, okay? And you guys had a problem, let's say, with one of the restrooms, one of the bathrooms. So if a tenant complains about a problem and says this needs to get fixed, well, first of all, if it's fixed immediately, then there is no reduction of rent. That's it. I have a problem, I give you a maintenance request, you deal with the maintenance request, done. There's no reduction because somebody's toilet backed up and there was a problem for a day or two, especially in a home where there's 3 other bathrooms. It's a non-issue.
Right.
The problem is if there's an ongoing issue that takes time to fix, and then the issue is, what is the diminution of value? If the rent is X, and now that I have this problem, what's the value of that? And there's no guide, there's no chart, there's nothing in the statute that tells you what that is. You have to work that out with the tenants. And you don't necessarily take their first, oh, well, I think it's X. Well, and that's the problem. Another issue, and this is going to be sort of similar, what I'm trying to say is that, landlords sometimes don't realize that tenants are customers. They don't take like the retail mentality. Rule number 1, the customer's always right. Rule number 2, never forget rule number 1. So, the idea is to rent your property, have people that are satisfied, especially, people that have apartment complexes and, corporate, they get reviews just like anybody else in the different websites, whether it be Zillow or whatever. And, I have some of my clients that have the worst reviews ever. And they're like, oh, well, it's all nonsense. The tenants are always complaining. Fact of the matter is, there's no set rule of what to do with reduction of rent, and everything has to be done on a case-by-case basis. And if you're fixing everything and keeping everything perfect, that's not even going to come up.
Right. Well, it's really hard especially in my case, I wanted to remedy it so bad that I agreed to reduce the rent, where obviously the rent reduction was something that was like pushed on us, right? At that moment. So it was just a situation where it was you do, I do, and I was just fed up with it. So, well, and I think that when landlords decide to evict someone, they've just about had it and they just want them out, right?
Well, that's, you're talking about 2 different things. Let me just finish what you're saying. You tried to be nice, which is another funny thing. Robert, I'm too nice. I'm too nice. Everyone tells me they're too nice. If I had $1 for every time a client told me that, in your situation, it was an ongoing problem. It was something that couldn't be dealt with in 1 or 2 days. And it's also a problem that once you thought it was fixed, occurred again. And then there's the problem with, wait, is this really my fault or is this the tenant's fault? Are they sabotaging this? Is there something going on here? And, if we're going to, have this podcast be discussing your case, we could talk about it all day. You know what I mean? It's those are, as I said, everything has to be done on a case-by-case basis. And, we could dissect what happened in your situation. You said, okay, fine. You guys want a rent reduction? I'll give you a rent reduction. But the rent's going to go back to the regular rent as soon as everything is fixed properly. And then it was fixed properly, but then it happened again. And now you're thinking, okay, are they sabotaging this? Right. And then you fixed it again, and then it happened again. And then finally at one point you said, all right, this is it. I fixed it. It's done. And you gave them the letter, and you said, okay, the rent's going to be this from now on. And they said, no. And that's what led us to this problem. And in your case, by filing the eviction case, you at least brought it to a head. Right? So you made the decision, look, I'm going to call Robert. I'm going to take his advice. And your situation was one of those where I had to make kind of a judgment call. Okay, how am I going to handle this? How are we going to do it? We spent time on the phone. We figured out the right amount of money. We did a 3-day notice. They didn't pay. We filed. And ultimately the case settled because most of them do. Every now and again, you go in front of a judge, you have a trial, but luckily yours settled. It worked out. When a landlord decides when to file or what to do, no landlord wants to file an eviction case. Landlords want to get paid, okay? And one of the things that I tell people is this. Your only leverage to get paid is the threat of an eviction. Tenant, if you don't pay, I'm going to have to evict you. That's your leverage. And if you do the eviction, I know you're going to say, oh, but I can sue these people for damages, and I can do breach of lease and breach of contract. Oh, yeah, sure. But collection is not easy, and it's a big pain in the butt. And the reality is most people take off, you never see them again. So once you do the eviction, you've pretty much lost your leverage. They're out the door, and so is any incentive to pay you. How many times people go, well, I'm evicted, but I still want to make good. Great, that's 1 in a million people. Most people go after them, you can try to collect, maybe you'll get a judgment, maybe you won't, and then you can chase them for the money, just like every other credit card company and every other creditor, out there with bad debt. So that's what you have to do. You have to, make your own decisions. You have to set your market rent. You have to do your background checks. You have to keep your property in good shape, and hope, hope the people that move in are good people, and, everything's going to work out great. And the good news is most of the time it does.
Yeah. Thank God. I mean, all the cases are solved, whether it's time is the main issue that we always wanted before, and usually these things take their process and their time.
Right, and I can go through that if that's what you want me to do. I mean, an eviction is a process, and time is money, and everyone's got to make that decision to draw the line in the sand. So look, let's start with this. Most evictions are for non-payment of rent. There are reasons to evict tenants that are not desirable for one reason or another, and there are other provisions of a lease that could be broken, whether it be having too many people, unauthorized occupants, unauthorized pets, causing damage, doing alterations. All of a sudden you send a work person to the house to do a repair, and you find out that they've built like extensions or done work or changed locks. There's all sorts of breaches of lease that have to be addressed, and some of those can result in an eviction. But let's be real. The vast majority of evictions are for non-payment of rent.
Right.
And the vast majority of people that don't pay aren't purposely withholding. Some people are. In your case, their argument was, well, we're withholding rent. Okay, we had an agreement, we weren't supposed to pay this much, we were only supposed to pay that much. And you didn't do what you said you were going to do, so we're sticking to our guns, and we're paying you the lower amount. So you actually had an actual dispute. Most evictions aren't based upon a dispute like that. It's people can't afford it. Some people just move into places that they can't afford. They want to try to get a nicer place. Sometimes things happen circumstantially where money runs low. And that's where the other judgment calls have to be made by landlords. What are you going to do? Are you going to evict these people now, or are you going to give them a break? And that's where I come up with I'm too nice of a guy. I've been so nice to these people. I let them go so long, and now, they one promise after another. Well, that's where it becomes a business decision for you. I'm just a lawyer. I don't tell people when to file a case. I just tell you what you need to do when you've reached that point that you want to go ahead and file. Right. And it's a process. And again, time is money. And, I'll take this anywhere you want to go. If you want to go through the actual steps of an eviction, I can go through that. So you let me know how, what you want to get from me, and I'll give it to you.
What advice can you give that landlord before they even sign a lease? I know you said make sure your property's ready, but
it's number one.
What type of checking on the tenant's background? Does that help in any case if you want to evict them later on, to say, hey, you sent me something that's fraudulent, you actually don't work here? Does that stuff hold up?
Right. Well, you're focusing the question specifically. I don't mind. This is what happened to you. You have people do a rental application.
Right.
You could check their references, people can fill out applications fraudulently. There's only so much information you're going to get on a background check. A lot of people can't afford to do the background check, or don't want to take the time. So, certain landlords, usually the big corporate landlords, make people fill out an application. They charge an application fee. They get their ID, their social security number, which you should always have. I mean, number one, know who it is you're actually renting to. I can't believe the amount of people that don't even check an ID. How do you know what their names are? And then you see these weird spellings. And I'm like, are you sure that's how their name is spelled? I mean, when I do the do's and don'ts, and I do occasionally I'll go to a real estate office where they have me as a speaker, and I have one of my talks is do's and don'ts, and I go through a little list of things. Another one is the actual eviction process. But when if you could afford an actual background check and and hire one of those companies that do it, and you can find out prior evictions or other judgments or court cases, you can use that as a guide. But it's not always, some of the people that have passed these background checks with flying colors could be terrible tenants. Some of the people that might have some things in their past are great tenants. That's not the issue. You have to use your best judgment. And again, these people are clients, they're customers, right? And if you have a vacancy and you've had a vacancy for several weeks or months, every month it's vacant.
Yeah, you get desperate. You get
right?
desperate and want to rent it.
These are all business decisions. So, some of the stuff that you're asking me is more of like, well, how do I handle this from a business standpoint than a legal standpoint? I mean, legally speaking, I look at a lease, I see what deposits you took, I see what was paid. To me, it's simple math. What do they owe? How far behind are they? And is there a reason they're not paying you? Okay, so that's what I look at. You do as much due diligence as you can. You do your background checks. You talk to these people. You do a walkthrough. You make sure your property is in great condition, and you deal with anything that comes up immediately. That's the best way to put yourself in a position to have a successful case if you have to, right? And if someone doesn't pay, that's when miraculously all the problems seem to come up. Oh, you didn't fix this, you didn't fix it. Well, you never told me about any of those things. Well, because now they're getting desperate too. I mean, and so you always have that question: am I going to work with people, or am I not going to work with people? So that's part of the issue of what you need to do as a prerequisite to filing and making a decision to even file or not. Some people, they fall behind every month, but they eventually come through and pay. So the question I'll get is, I'm just done with these people. They're late every single month. I really just want them out at this point. That's not the way the law works. Every time someone's behind in rent, you have to first give them a 3-day notice. If they turn around and pay, that resets the clock. So you can't go ahead and actually file. And you can say, well, their lease is up in 6 months. You don't have to renew them. So all of these things factor in.
That's great. I have a question. I remember that the laws changed when COVID hit, as far as what time you're allowed to have the tenant stay on the property. Did any major law changes occur in the last couple of years that you can make us aware of?
Yes, absolutely. I think you're referring to when a tenant was month to month.
Right.
So there's proper written notice that either party has to give. So if the tenant wants to leave, they have to give the landlord notice. If a landlord wants the tenant to leave, they have to give written notice. So you can't just say, okay, get out tomorrow, okay? The statute requires proper written notice to terminate a month-to-month tenancy. So Florida law, pre-COVID, was either party had to give not less than 15 days notice prior to the end of any monthly period, which isn't, again, which you want to get into things where people make mistakes, is misreading these things. Everyone, I got to give them 15 days, 15 days. No, it's not 15 days. It was not less than 15 days prior to the end of any monthly period. So when COVID hit, they had eviction moratoriums. And those eviction moratoriums were strictly on non-payment. So that's when basically people were going to get rent assistance, and they had the CARES Act and different things that prevented landlords from terminating tenants and legally evicting them. But what was happening was a lot of these people had, expired leases. And, And
a lot of people do that. A lot.
right. I mean, if your lease is expired, COVID or not COVID, you're supposed to be moving out, right? I mean, the lease has a beginning date and an ending date. You could be paying perfectly. It's got nothing to do with anything. You're supposed to leave. So after, when people were month to month, and you couldn't evict anybody for non-payment of rent, people were resorting to giving 15-day notices or notices of termination of month to month. And what happened was I can only speak for South Florida, but Miami-Dade County, Broward County, even Palm Beach County, they had local ordinances. And they were getting together and they were passing these ordinances that were referencing that part of that provision of Florida statutes, which is 83.57. Not anyone's going to look it up, but go ahead if you want to. 83.57 Florida statutes has how much notice you're supposed to give if it's week to week, month to month, year to year, what have you, quarter to quarter even. So all of these local ordinances were now creating a situation where you had to give at least 60 days notice. And it wasn't just for terminating a month-to-month tenancy. It was if you wanted to raise the rent more than 5%, because that's when people were coming down, the rents were skyrocketing, and all these landlords were like, oh, crazy, I can double the rent. No. All the local governments, Miami-Dade, Broward, Palm Beach, and probably other parts of the state were passing these ordinances that you have to give at least 60 days notice to increase the rent or to terminate a month-to-month tenancy. That lasted until about a couple of years ago. I'm not sure if it was the 2022 legislative session or the 2023 legislative session, but Florida passed a law. There were essentially two changes. One was what they called a preemption law. So everything preempts to the state. So all those local rules, all the municipal and county ordinances went bye-bye. They passed like a tenant's bill of rights in Miami-Dade. You had to have them sign like a special tenant bill of rights, and they had all these different things. All of that went bye-bye. Nope, because none of that exists in state law. So everything preempts to the state. But one of the things they did do is they changed 8357. So the 15 days became 30. So all the 60-day provisions went bye-bye. All the bills of rights went bye-bye. The 60 days to raise the rent more than 5% went bye-bye. There's no rent control in Florida. And any of the local governments that tried to impose it, now that's gone. So that was the big change.
Wow. It just like changes for landlord and tenants, there was a lot of changes in lenders lending money. So now most of my private investors and private lenders do not lend if it's not their homestead. I don't know. It's just that it protects the owner from being foreclosed if it's your primary residence versus not. Like they made a big thing about that. So I knew there was kind of like a change with tenant landlord. I have a quick question just to break out of this. How did you get into evictions? Why evictions?
Well, okay, I'll answer that. I mean, if it's a quick question, I don't have a quick answer for it. So it's like anything else. You get out of law school. I had a job, and that didn't last very long, and I ended up opening my own practice. And when I opened my own practice, I started doing anything that came in the door. Right. So I had a few mentors and people that were helping me and referring me business, and I was doing a little of everything, including some evictions. And the main story, what got me into evictions, was I had a very, very close friend from law school. He's still one of my best friends to this day. His uncle had a property management company. Okay. And my friend, who we graduated law school together, for a while, he didn't really want to practice law. So we got out of it and he went back to graduate school. So he was in Tallahassee and FSU and different places in graduate school. And his uncle, who would have given him the business, ended up saying, look, Rob, I need you to do evictions, so here's what I got. And he gave me one case, and then two, and then three, and then five. And he was a very smart guy and a very experienced guy. And he knew kind of a lot of ins and outs and kind of mentored me a little bit in this. And next thing I know, I'm filing evictions. And you learn. Just like anything else, what are you going to do? You're going to learn. You're going to read the statute. You can read a lease. You can figure out what you're going to do. And I started doing evictions, but kept everything else going on. But as my eviction practice grew, I started dropping the other stuff because, you want to try to be an expert in something.
Right.
And one of the things that happens when you're a young lawyer is you find your mentors, you find your friends, you find your colleagues, and anytime you have a question, that's it. You're making that call. Oh, what would you do in this situation? Oh, how would you handle this? Or do you have that form? Do you have a copy of this? Joe, what do you use for that? Well, it got to the point where with evictions, and I'll still call somebody just to verify what I already know, but basically I'm now the person everybody calls.
Right.
So all my colleagues call me.
And you're also a very good negotiator because along with, you want to take out the tenants from the house and basically, please your client. You're a very good negotiator as far as making sense to get it done.
Well, a lot of the negotiation is with the client, right?
Right.
The clients drive the bus. And you guys, I thought, were very helpful to me. Because, as far as I'm concerned, people suggest, look, money is never an issue as far as I'm concerned. One of the things I tell people is I'm an eviction attorney. I'm not a collection agent.
Right.
And if you focus, and I could, without getting too in the weeds, because nobody wants to hear all the reasons why I stopped doing collections. Because that's what my first job out of the box was with a collection firm. And I never had a problem going after money, filing for collection. We used to do, when you used to file an eviction, you used to do 2 counts.
Right.
So count 1 was you're filing for eviction, count 2 was breach of contract. And there's a long list of legitimate reasons why I stopped doing count 2, and I don't even bother with collections anymore. And at the end of the day, and we started saying this in the beginning, time is money. Right? So the sooner you get somebody out, the sooner you can get somebody else in that's going to pay you.
Right.
If you have a property that's renting for $3,000 a month, that's $100 a day. And, if you have somebody that says, I'll get out this weekend, but I'm not going to pay you. You have to forgive everything. And a lot of them are like, oh my God, they owe me like $6,000. Why would I do that? And I'm only holding a 1-month deposit. And who knows if the place is trashed? And I don't want to, let them get away with this. And they're just going to do some other lawyer. What do you care? Okay, they're going to get out this weekend. You have $3,000. Okay, so you let them go. And that's how you do it. Is that good negotiation? The first person I have to convince is my client.
Right.
They're going to get out this weekend, okay? So are you going to make a big deal? You're going to insist they pay you everything? If you insist they pay you everything, then you're not giving them any incentive. There's carrot and stick. If they're agreeing to leave, but they're not going to give you any more money,
right?
Then, why wouldn't you take them on that deal? Because the reality is the eviction itself, and one of the problems is that the process, there's just things built into it that we have no control over. When it comes to doing an eviction, I'm not ashamed or afraid to say, why would I be ashamed? I'm not afraid to say this. I'm not arrogant, I'm not conceited, but when it comes to basic eviction practice, there's not another lawyer in the South Florida area that can get an eviction done any faster than I can. You could do it as fast, but you can't do it any faster. You just can't.
What's the fastest you can do an eviction from start to finish?
Well,
if all goes good.
Okay.
In a perfect case.
So let's just go into that spot. But I want to just finish the thought about you make the decisions you make. And that's why, if you're a landlord, why would you just say, okay, tenant, just leave and don't pay me any more money? The reason is because it could take weeks.
Absolutely.
Right? And if they're going to milk it and you're going to, you're going to insist on payment, again, cases settle all the time, by the way. Cases settle all the time. I don't want to say the majority, and I'm not going to put a percentage on it. But if a tenant has money and they want to stay, we could always do a payment plan. We could always say, okay, you owe me $6,000, you owe me 2 months, plus the late fees, plus now all the legal fees. So now the total is $7,500 or whatever. How are you going to pay me? And if they have the money and they want to stay and you don't think they're terrible people, you just want to get paid,
right,
then you'll work something out with them. It's not a matter of negotiation per se. I don't think negotiating is my strength. And I think that's why you guys came in. I probably would have accepted less if you left it up to me. But at one point you guys said, no, we want this. And again, without getting into the details of your case, what made that a little easier is because they ended up putting money into the court registry. So that gave us a little bit more wiggle room. And then I put pressure on them when we got into another month and I filed another motion. And that really got a phone call and that really got things going. So you have to press it. But I'll answer the question about the eviction process. An eviction process goes like this. I'm going to just focus on non-payment deferral.
Right, non-payment.
Okay, so if somebody hasn't paid, first step is a 3-day notice. So that's 3 business days right there. You give them 3-day notice. They have 3 business days to either pay or vacate or do neither. Assuming they do neither, the next step is filing the eviction lawsuit. So that's the next business day whenever that 3-day notice expires. So what I will tell someone when they call is I strive to file the case as soon as possible. So if a 3-day notice expires on a Tuesday, I'll try to file the case on Wednesday.
Right.
It's the best I can do, right? I don't know if there's any firms going, yeah, we'll get to it next week. No, I understand time is money and that's part of it. So you file the case. After the case is filed, I now have to wait for a clerk because I'm electronically filing. I'm submitting documents, I'm uploading, I'm submitting my credit card information, I'm hitting click, right? File. And then I have to now it's in some portal somewhere where a clerk has to receive it, review it, and accept it, where I have a case number and I know what judge it is. That could take minutes. It could take hours. It could even take a few days, depending on where I'm filing it and how busy they are in any given week. So that could happen within a day or so. Okay, when you ask me what's the fastest, okay, let's say I do a 3-day notice on Monday. It comes due on Thursday. We count Tuesday, Wednesday, Thursday. They don't pay. I file on Friday. Okay, now I file on Friday, and let's say the clerk accepts my filing on Friday. Well, now I have to get the summons issued. In Miami, that usually means I'm sending somebody to the clerk's office. They just in the last couple of months started doing electronic summonses where I could upload it and then the clerk will put their seal on it and send it back to me. But I still have to drop off a mail-out copy, and that's sending a process server. So now if I file it on Friday, am I going to have a summons issued and served on Friday? Probably not.
Right.
Okay, but let's just say in the hypothetical best case scenario, I can get the summons on Friday and my process server will serve Friday or Saturday. You don't lose a day if they serve on the Saturday. So now I'm counting 5 business days because that's the process. After a tenant is served with an eviction summons, they have 5 business days to file a response. So that would be the following Monday, Tuesday, Wednesday, Thursday, Friday, assuming there's no holidays.
So it's that quick. So 3 days, let's say 2 days for the service and 5 days.
Right. I just gave you the best case scenario. So if we do the 3-day notice on a Monday and it expires on a Thursday and I file the case on Friday and I'm lucky enough to get my summons issued on Friday and I send my process server and he serves it either Friday or Saturday, now their tenant's answer to the court will be due the following Friday.
Right.
That's your best case scenario. Okay? So they either file something or they don't. And what I've found is that at least half the people don't file anything.
So what happens after that? They don't file.
Okay.
It goes faster.
Great. Well, not necessarily. Sometimes it depends whether they put money into the court registry or not. Right. It depends what their answer is. A typical answer is really just a hardship thing, which judges can't do anything about. If some people want to file a response and going through all the things the landlord didn't do, a lot of times when we talk about maintenance issues, and a lot of times when somebody's getting evicted, they'll file an answer with all the problems of the property, none of which the landlord was ever told about before. But that's another story entirely. So just to focus on best case scenario, most people don't file a response. If they don't file a response, then on the following day, I file a motion for default. Again, I'm e-filing.
Right.
Okay? So now all I can do, if they have 5 business days to file a response and they filed nothing, then on the next business day, I can file a motion for default. And then again, I'm waiting for a clerk to accept that that paper, say filing completed, and then in Miami-Dade, I actually have to wait for the clerk to enter a default, which could be the same day, could be a week later. And I don't know. I have to keep checking the court file. I have to keep going online and clicking on my case on the online docket to see if my default was entered. In Broward County, they do it all electronically. So as soon as the default is entered, I get an email and I see it. In Miami, I have to keep checking. So again, best case scenario, I e-file my motion for default. Let's go back to the days I was talking about. So we do the 3-day notice on a Monday, comes due on a Thursday, file the eviction lawsuit on Friday. I'm lucky enough, best case scenario, to get the eviction summons issued on Friday and served over the weekend. Their answers to do the following Friday, they file nothing. So then figure that Monday. So now where are we? If I did the 3-day notice on one Monday, we're now 2 weeks. So that Monday that I'm filing a motion for default is 2 full weeks. And if I'm lucky enough, you're asking best case scenario, if I'm lucky enough to get the default entered on that Monday, which is usually not the case, but if I get the default entered that Monday, now the next step is submitting the proposed final judgment. So that default that I get is entered by a clerk, where the clerk looks at everything and goes, okay, you filed this case, you got service of process on this day, I'm counting the 5, you file your motion for default, the tenant has filed nothing. Remember, they're a defendant now in a lawsuit. They filed nothing, so a default will be entered against the defendant. Once the default is entered against the defendant, then I have to upload a proposed final judgment. That's essentially that's the goal of the lawsuit, to get awarded possession, okay? Now, there are some judges in Miami, let's focus on Miami-Dade. There are some judges that they're excellent with their paperwork. You submit an order, you'll have it back that day, next day, 2 days at the most. There are some judges, and we all know who they are, okay? I'm not gonna mention any names, but I have conversations with clerks. We all know who they are. There are some judges that I don't know what they're doing. I don't know if they're deliberately just taking their time or if they're just so super busy. Why would some judges be so super busy and other judges be able to look at their stuff and sign papers right away? I don't know. I just know that some judges take a while. Okay? So if you're lucky to have one judge who's very conscientious and looks at their stuff every day and clears out their stuff every day, and you get your judgment within a day, you're one of the lucky ones. So back to our best case scenario. If I do the 3-day notice on a Monday, file on the following Friday, get service of process that weekend, their answer is to do a week from Friday after that, 5 business days later, I get my default entered on the following Monday, Tuesday, 2 weeks later, and let's say I'm lucky enough to get my final judgment by Tuesday. So now I'm like 15 days in. That's my best case scenario. That is pie in the sky, as fast as it possibly can happen. Okay? I don't care who you are as a lawyer. I don't care if you're doing it by yourself pro se. That is as fast as it possibly can go. 15 days. And that's just getting a judgment.
Then there's a process to
Okay? So now you've got your judgment that says plaintiff is awarded possession of the property. They give you the address for which let writ of possession issue forthwith. So the writ of possession is the final eviction notice. So one thing we didn't address today, and I'll just say it now, there's no self-help in Florida. If you could just go in and change the locks, then we wouldn't even be having this conversation right now.
I know.
This podcast episode wouldn't exist. I'd say, go ahead, just change their locks, put everything in hefty bags and throw it on the street.
Absolutely not.
Okay, if you do that, you can get sued.
Absolutely.
Okay, and that's a whole nother podcast. Okay, so there's no self-help. There's no locking people out. There's no shutting off their utilities. There's no unhooking their AC. There's no turning off their gate pass so they can't get into the property in a community. None of that. Okay, you have to go through the legal process of an eviction. And you cannot physically remove people. Okay, you're not going to go in and grab somebody by the scruff of their neck and throw them out. You'll get arrested for battery and you're going to jail. Absolutely. Okay, so who has the power and authority to actually remove somebody? Well, in this case, it's the local sheriff's department. I know Miami-Dade talked about rebranding to Miami-Dade Sheriff, and I actually make out my check to Miami-Dade Sheriff. But so far, they're still branded Miami-Dade Police Court Services Bureau. But that's down here, that's the local sheriff's department. So only they can serve and execute a writ of possession. It's not the city of Miami police, it's not any municipal police department. It's the county-wide sheriff's department. In Broward, it's BSO, Broward Sheriff's Office. Palm Beach Sheriff's Office. Here, it's Miami-Dade Police. So that's the only way you're gonna actually, and now, again, most people do take off at some point. That's not what we're talking about. We're talking about the process. And the process involves this writ of possession. So you're not gonna get a writ until you get your judgment. And so after the judgment is entered, then I could submit the writ for issuance. Again, one of those quirks, in Broward County, the writ of possession is issued electronically. So I can go to my e-filing portal, I can submit the writ, and whether it's an hour or a day or two later, boom, I get filing completed, and I get in my inbox the issued writ with the clerk's signature and seal on it electronically. I can print that from my computer, and I could take that over to BSO. In Miami-Dade, only the clerk can issue the writ manually. So I'm either mailing it to them, or I'm driving down there.
Wow.
Now, you're asking best case scenario? I'll give you best case scenario. The only best case scenario is the lawyer personally driving down to the clerk to get the writ issued. Why? Well, Broward, I guess they're not really worried about people just printing the thing and taking it over themselves. But in Miami, they're much more cautious. I actually have to give them my ID and bar card in order for them to give me back the issued writ so I can drive it over to the sheriff's department.
Wow. And what's that turnaround time with them?
That's the big problem. So now we just went through a scenario where, again, best case scenario, I'm getting a judgment in about 15 days.
Right.
Now, if I get my judgment and that judgment shows up on the docket, I can drive down to the clerk, I can get the writ issued, and I could take it over to the sheriff's department or Miami-Dade Police, drop it off with them. Now, the writ of possession is a 24-hour eviction notice. So they'll go and they'll post it, and it says, okay, 24 hours, got to be out. But again, you're not executing the writ. You have to wait for them to execute the writ. And they schedule it. So you have to wait for a phone call from the Miami-Dade Police Department Court Services Bureau saying, hi, this is Miami-Dade. We're going to schedule your writ for lockout. Okay, when are you going to be there? Oh, we'll be there next week. Okay, and by the way, you're lucky if it's 2 or 3 weeks later that you even get that phone call. So that is the biggest X factor.
Right.
And that's the biggest delay. And I have no control over them. So look, if a judge is taking too long to do something, and as I told you, there are those very slow judges, I will occasionally send an email to their judicial assistant saying, oh, is there anything I can do? Every now and again, you don't want to be that guy, because I don't want to, have them spit on my food at a restaurant when you complain. Because that, you don't want to have a bad reputation, and that's part of it. But every now and again, if it gets a little long, I will make a phone call. If a clerk's taking a while, I can make a phone call to a clerk. You could do things to try to speed things up, try to expedite. But the sheriff, you have no control over. Now, Miami actually has what they call expedited service. But that costs $1,600.
Wow. Right?
The regular fee is $115. You want expedited, it's $1,636. Now, for a lot of people, look, if you have an expensive rental, it could actually be worth it. Right. Now, most people don't hang around when they see a 24-hour eviction notice, but a lot of people know the system. So that's the part I can't predict for people. Right. So knowing that the writ in and of itself takes at least as long as the time it took me to do my 3-day notice and get my judgment. So at least. So if I'm 15 days just to do my 3-day notice, file my case, and get my judgment.
Right.
Oh, and by the way, that 15 days is like best case scenario. It's really more like 20 to 22, 23.
Right.
Okay, and on a good day, it's at least that long to serve and execute the writ.
Right.
And that part I have no control over whatsoever. So that's the steps.
A perfect scenario. I want to take it back just a second. Would you agree that most evictions occur because they don't pay or maintenance issues, right? Most of them.
Most evictions are for non-payment.
Non-payment. And
The maintenance issues are the excuse for not paying.
right.
Okay, and that's why I say it's so important to deal with all of that. That was the first question you asked me. What could a landlord do? You know, and so number one is make sure your property is in perfect condition and fix everything right away, because then you're taking their thunder. If they're thinking they're going to be able to withhold rent and buy time and not pay you because the place is in bad condition, well, then just shoot that down and make sure everything's perfect. So if you do that, you're not going to have an issue. So back to what you were saying, yes, the vast majority of evictions are for non-payment of rent.
So if a tenant has an issue where they can't work, or they lost their job, or they're ill, do the judges sympathize with them? Like, do they take their part and make the tenant, the landlord, accept less payment? How does that kind of go on like?
Look, the short answer is it has no effect. The short answer.
No effect.
The short. Again, everything is case by case.
Right.
Hardship is not a legal defense.
Okay.
Simple. That's the answer.
That's the
now, I guess you've gathered in the last few minutes, or however long we've been talking now, that I can expand on virtually every answer. And I could do it on this one too. There are situations, depending on how heartfelt the answer can be and what the circumstances are, that, you know, maybe some time is bought. I have found that in the vast majority of cases, there's a tenant is actually wasting their time doing that. You know, if you're going to file a big long answer, going through the job losses and all you're really doing is admitting the eviction, right? And one of the interesting things about Miami-Dade, again, this is like one of those things getting in the weeds of what's the difference between filing an eviction in Miami versus Broward. I could do a whole podcast on that.
Right.
But one of them is that sometimes filing an answer, which people think will buy them some time, is the wrong move.
Right.
Because if I see you filed an answer and there's no money, you didn't put any money in the court registry, the first thing I'm going to do is file a motion to strike your answer, because you didn't follow the law. The law says you have to file an answer and pay the rent money into the court. And if you don't do that, if you just file a long answer with hardship, with no money in the court registry, I'm going to file a motion to strike your answer. And as soon as that motion to strike is accepted, now I'm going to submit my proposed order and judgment to the judge.
Wow.
Whereas if I'm filing a motion for default, I might have to wait 2 or 3 or 4 days for that default to be entered by the clerk. And the judge is not going to grant my judgment until the clerk enters a default. But if a tenant files an answer and there's no money, and I file a motion to strike, I'm not waiting for a clerk's default. So in a really weird way, sometimes filing an answer in Miami could be the wrong move. But, you know, again, the short answer to your question is hardship does not, most judges do not, oh, you're going through all of this problem? Okay, you know, I'm just going to grant an extension. The time that does occasionally come into play is, let's say you've gotten to the point of the eviction where you got your judgment, you got your writ, and that 24-hour writ of possession might have even been posted. Now people are freaking out because they don't realize it takes the sheriff 2 or 3 or 4 weeks to even come back. They're thinking, oh my God, I can't leave in 24 hours. So they run to the clerk's office and they'll file an emergency motion to stay the writ of possession. And they'll go through, I just had surgery or whatever, I just gave birth. It could be a million different things. And then I'll get a phone call from the judge's office going, hey, Mr. Warman, this is so-and-so calling from Judge so-and-so's office. We just got this motion to stay. A lot of times I don't even see it because they're not going to send me a copy immediately. And they're taking it to the clerk by hand. So I'll get a phone call and they go, look, they just filed this motion to stay. Would your client have any objection to giving them a week or something like that? And I usually say no. They have no objection because I know in my head it's going to take the sheriff 3 weeks anyway, and if they're going to be out by Saturday, if that's all they're looking for, and again, there are plenty of times people will even call me directly and say, look, I need more time. I promise I'll be out by X day. And, so again, it's case by case. You talk to your client, and it's a good idea. So a lot of times you're actually in a hearing or something, and you'll be in a hearing and the tenant goes, look, I know I didn't pay, but I can be out by next week.
Right.
And the judge looks at you going, will your client agree to give them till next week? And what they're really saying is, if they're out by next week, I'll just sort of dismiss the case. We'll do a court order that says tenant agrees to be out by this week. If they're out by then, case will be dismissed. If they're not out by then, judgment and writ will issue. Great. If a judge says, will you give them time? They'll remember you. You say yes. I'll give you time. Especially my clients that file cases all the time. You're not really losing anything. And, look, we don't have crystal balls. We can't look into the future, and that's something, just as a general principle, people ask me all the time, Robert, I got a phone call. The tenant says they're running into difficulties, but they'll be out Saturday. I don't know. The 3-day notice expires on Wednesday. I could file the case on Thursday. What should I do? I don't like telling people what to do. I go, well, do you have a crystal ball? No, I don't have a crystal ball. Oh, okay. Well, do you know whether they're going to be out on Saturday or not? No, I don't know whether they're going to be out on Saturday or not. Well, if you knew, you wouldn't pay me, right? Why would you pay me to file the case if they're just going to be out in 3 days? Well, I can't be the guy that says, you must pay me because I don't trust them. If you make the wrong call and they're not out, then you've just wasted valuable time. Saturday has a way of turning into Monday, and Monday has a way of turning into next weekend.
Right.
We don't know that. But those are all the things that are part and parcel with eviction practice. And those are things that landlords have to deal with every single day of their lives.
So I have one last question. I'm asking this because I have a lot of clients that actually tell me, and you're going to say if it's a myth or not. So I get this suggestion to, hey, don't show the apartment to people who have minor kids, because if we have to evict them, that's going to be a major setback because they're going to come up with X amount of excuses. So is it a myth that renting to a person that has minor children or an elderly person make the process of eviction longer? Or can it?
That is a myth.
That's a myth.
And that myth is officially busted. Look, it's just what you were asking before. Are there judges that are sympathetic?
Right.
Are there situations? There's always situations. Again, it comes up more at the end than at the beginning, but there are situations where people can buy time. There are situations where if you say something in your answer of some sort of legal, the biggest thing that gets people time is claiming that they've paid already, or that the amount of money claimed in the 3-day notice is not correct. And if they can give plausible reasons why that's the case, some judges might set a hearing on what we would call a rent determination hearing. Because I already said you have to put money into the court registry, but if there's a real good faith doubt as to how much money should be put in the court registry, then you could have a hearing on that. But that, again, is a factual and legal issue that's got nothing to do whether you've got elderly people, whether you've got babies, newborns, schools just starting school. can't evict anybody in May because we only have a week left, and there's school. What are you going to do? All of these things they're not, again, the landlord wishes they weren't in this situation.
Right.
If you had been paying or doing what you're supposed to do, we wouldn't be in this situation. Some people, it could even be when a lease expires. That's just bad timing, but if you've promised the place to somebody else, or you're supposed to close and you've expected a property to be vacant, there's a lot of factors that go into that. But don't rent to kids with small children, or autistic kids or handicapped people. None of those are legal defenses. There's nothing in the law that says an eviction has to be delayed or more notice or other accommodations. There are accommodations for handicapped people,
right,
but that's a different story in and of itself. You could read about, somebody might need a bar installed or ramps. All of those, that's a separate issue. It's got nothing to do with what you asked, but it's a complete myth that having, kids or elderly or any kind of, medical issue, prevents or stalls an eviction. It shouldn't. I mean, in those rare cases where, a judge does want to give a few extra days, they never go, you can't. It's a matter of maybe just giving a few extra days. That's it.
Right. Well, we can go on and on hours on evictions and landlord-tenant issues. There's a ton of them out there. I just wanted to leave everyone with some valuable insight. Very much recommended attorney for evictions. We'll go ahead and post his information at the end of this podcast. If you guys need to reach out to him, he'd be more than glad to do so. Highly recommend it again. Robert, thank you for joining me in the podcast. And I hope to see you, but I hope not to see you or deal with this, Kitty.
I hear that again. Robert, I love you, but I wish I didn't have to call you.
Yeah.
Look, Iris, this was really a treat. Obviously you can, I don't mind talking about evictions. I have these conversations all day, every day. I appreciate the opportunity. I appreciate the marketing. But if you ever have any questions, if you ever need anything, if you ever want to do a part 2, anyone that needs any help with evictions, just give me a buzz.
Yeah, definitely. You do also other like probate.
I do some probate. I don't, I try to take the easy ones where the kids and everybody are agreeing. If bro and sis can't get along as to who's going to get what, or something convoluted, or there's some issue, then I usually refer those to other colleagues. Okay. But basic probate, absolutely, those can be good cases. I handle some of the related stuff. I mean, I usually don't take a lot of complicated things with people that aren't my existing clients. But if I'm doing evictions for people and then there's a code issue and I need to go in and get another 60-day extension, so I go to the special master hearing, or I help out with some violations or different things here and there, I try to focus on evictions to the best of my ability, because that's what I'm expert in. And when you start getting other cases, it takes your eye off the ball of the time management that's involved. Some of my clients will send me 5 cases at a time, 10 cases at a time. And if you're doing another kind of complex litigation, one of the things is I do everything. I'm hands-on. I give concierge service. I do basically all my own work. I answer my own phone. I reply to all my emails.
Replies to the phone
so
calls,
I try to stick to what I know.
Yeah.
But, if somebody has a question, if I can't help you, I'll try to steer you in the right direction.
Thank you so much. I really appreciate your time. And you guys, I'm going to leave the information at the end of the podcast. Feel free to contact him.
All right.
Thank you.
Thanks.
Thank you.